Is offering a suspect a moral or psychological excuse for committing the crime, essentially offering them a promise of leniency if they confess. Social psychologists and other law enforcement critics oftentimes suggest that during an interrogation, if the investigator offers the subject a moral or psychological excuse for committing the crime, such as blaming an accomplice for suggesting the crime, the influence of alcohol or drugs on clouding their judgment, the financial pressures they were experiencing, something that the victim said or did, etc., they are actually suggesting, at least indirectly, that if the subject had a quote-unquote good reason for committing the crime, it would minimize their punishment. And therefore, it should be a technique not allowed. The courts completely reject this premise. Detailing some of the court decisions, it's important to understand why investigators offer the subject some type of moral or psychological justification for committing the crime during the interrogation process. According to criminal psychologist Shad Maruna, studies indicate that the majority of criminals either make excuses for or attempt to justify their actions, quote, as a way to mitigate the guilt, end of quote. Quote, criminologists have interviewed every imaginable sample of individuals who break the law and found remarkable consistency in the use of what we call techniques of neutralization, Maruna explained. There have been studies of deer poachers, terrorists, rapists, shoplifters, cyber hackers, murderers, you name it. And yet the individuals involved tend to use a very consistent and discernible number of post hoc rationalizations to account for what they did. These techniques of neutralization form the basis of a concept known as neutralization theory, which was posited by sociologists David Matza and Gresham Sykes in the 1950s. The theory holds that criminals are able to neutralize values that would otherwise prohibit them from carrying out certain acts by using one or more of 5 methods of justification: denial of responsibility, denial of injury, denial of the victim, condemnation of the condemners, and appealing to higher loyalties. I didn't really hurt anybody. They had it coming to them. They asked for it. I didn't do it for myself, are examples of neutralizations. Neutralizations, also referred to as rationalizations, are defined as justifications and excuses for deviant behavior. Denial of responsibility is when an offender proposes that he or she was forced by the circumstances they were in to commit the crime. Denial of injury means insisting that the crime wasn't harmless, the person wasn't hurt that bad, there wasn't that much damage, etc. Denial of the victim involves the belief that the person on the receiving end was asking for it, they deserved it, they provoked it, etc. Condemnation of the condemners is when the criminal claims that those criticizing or dishing out punishment are doing so out of spite or to shift the blame from themselves. And the final method, appealing to higher loyalties, involves the perpetrator believing that the law needs to be broken for the good of a smaller group, a gang, a group of friends, family, etc. So in view of the rationalizations and justifications utilized by criminal offenders to deal with their guilt, the suggestion by an investigator that an accomplice talked them into doing it, the victim was accidentally shot, the subject's financial pressure caused them to act out of character, or blaming the victim for doing or saying something that provoked the incident, are oftentimes the justifications the subject has already adopted in their own mind. Dr. Richard Leo and other social psychologists and false confession experts refer to this approach of offering the subject, quote, a good or understandable reason, quote, for committing the crime as essentially a suggestion that such an explanation would minimize their punishment. Here's an example of Dr. Leo's testimony on this subject. Quote, so minimization is a recognized interrogation technique that whereby the interrogator tries to minimize the or downplay the seriousness or consequences of the alleged act to make it easier for the suspect to admit to it, because it's less serious or perhaps portrayed as not even criminal at all. His testimony continued, so by minimizing the consequences or the outcome or the punishment, Sometimes minimization communicates also implicitly a suggestion or promise of either leniency or reduced punishment in exchange for cooperation. There are two types of acceptable minimization that can occur during an interrogation: minimizing the moral seriousness of the behavior, minimizing the psychological consequences of the behavior. The third type of minimization is to minimize the legal consequences of the subject's behavior, which we teach never to do. In his testimony, Leo says that interrogators, quote, downplay the consequences of the act, end of quote, and that by, quote, minimizing the consequences or the punishment. Sometimes minimization communicates also implicitly a suggestion or promise of either leniency or reduced punishment in exchange for cooperation, end of quote. In the Reid technique, we never teach to downplay the consequences of the act or to minimize the consequences or the punishment, because the courts have consistently ruled that promises of leniency can be coercive. In their white paper prepared for the American Psychological Association entitled Police-Induced Confessions, Risk Factors and Recommendations, the authors, one of whom was Richard Leo, agree with our position. They state in the article that, quote, minimizing the moral seriousness and the psychological consequences should be allowed, but that minimizing the legal consequences should not be allowed. The authors of the article were Saul Casson, Stephen Drizzen, Tom Grisso, Gisliga Johnson, Richard Leo, and Allison Redlich. It was published in Law and Human Behavior. The emphasis of the Reid technique is to create an environment that makes it easier for the subject to tell the truth. And an essential part of this process is to suggest face-saving excuses for the subject's crime, which may include projecting the blame away from the subject onto such elements as their financial pressures, the victim's behavior, an accomplice suggesting the idea, their emotions, the influence of alcohol or drugs, without minimizing the legal consequences of the subject's behavior. We're very specific on this point. Here are simply three examples of what we say in our book on this topic. During the presentation of any theme based on the morality factor, caution must be taken to avoid any indication that minimization of the moral blame will in any way relieve the suspect of criminal responsibility. Here's a second statement. As earlier stated, the interrogator must avoid any express or intentionally implied statement to the effect that because of the minimized seriousness of the offense, the suspect will receive a lighter punishment. And as a third example, in applying this technique of condemning the accomplice, the interrogator must proceed cautiously and must refrain from making any comments to the effect that the blame cast on an accomplice thereby relieves the suspect of legal responsibility for his part in the commission of the offense. The courts reject, they do not accept the premise that minimizing the moral seriousness or psychological consequences of the subject's behavior is tantamount to a promise of leniency. Here are a few examples. The Supreme Court of Canada stated, quote, there is nothing problematic or objectionable about police when questioning suspects in downplaying or minimizing the moral culpability of their alleged criminal behavior. In Commonwealth versus Cartwright, the Massachusetts Supreme Court stated that nor have we concluded that an interviewing officer's efforts to minimize a suspect's moral culpability by, for example, suggesting theories of accident or provocation are inappropriate. In People versus Rotten, Dr. Leo testified that the interrogator suggested to the offendant that, quote, the offense was accidental, thereby minimizing the subject's perception of the consequences of an admission and implying that an accidental killing might result in leniency. This technique can increase the risk of a false confession, end of quote. The court rejected this premise and the jury convicted the defendant of first-degree murder. In Gomez versus State, the U.S. District Court stated the following: suggestions by investigators that killing may have been accidental or resulted from a fit of rage during a drunken blackout fall far short of promises of lenient treatment in exchange for cooperation. In U.S. v. Hunter, the U.S. District Court upheld the lower court's decision to admit the defendant's confessions, stating that, quote, while Agent David's repeated assurances that she understood how Hunter must have felt and that she, Agent David, believed the incident was an accident were no doubt persuasive and inducing, nothing in those statements constitutes a quid pro quo promise to Hunter in exchange for a confession. In U.S. v. Casey, the U.S. District Court examined the issue of what statements constitute a promise of leniency that would render a confession inadmissible. They found that such statements as, you can help yourself out by telling the truth, this is probably going to be a 50-year to life type count, you know you need to mitigate to try to help yourself out. You just need to make a decision if you want to do something like that to explain to the world why this went down. But it's up to you. I mean, this is to help you. It's not going to help me. I don't need the help. Whether the truth hurts, you get a benefit for the truth. And the truth can hurt. It's not fun talking about this kind of stuff. The court stated, a promise only vitiates consent if it is sufficiently compelling to overbear the suspect's will in light of all attendant circumstances. Reciting possible penalties or sentences does not render a statement involuntary. In Smith v. State, the Supreme Court of Georgia held that statements by the police detectives during a custodial interrogation to the effect that shooting the victim was an accident in response to the victim lunging at the defendant did not constitute a slightest hope of benefit that could render the defendant's confession inadmissible. In State v. Turner, the Nebraska Supreme Court held that misinformation by police officers during the defendant's interview that felony murder would receive a lesser sentence than premeditated murder did not overcome the defendant's will so as to render his confession involuntary based on purported promises of leniency. In Commonwealth v. Johnson, the Supreme Court of Massachusetts upheld the admissibility of the defendant's confession, noting that such a statement as, quote, if for some reason you went in the restaurant to do a robbery and somehow the gun went off accidentally, end of quote, was not a statement that suggested leniency. In People v. Batiste, the defendant had claimed his confession was coerced because it was the product of deception or implied promises of leniency by the officers. From the court's opinion, Batiste argued in the trial court that officers made an implied promise of leniency when they suggested he might have acted in self-defense. That argument lacked merit. The court went on to say, here, as in People v. Carrington, suggestions that the homicide might have been an accident, a self-defensive reaction, or the product of fear were not coercive. They merely suggested possible explanations of the events and offered defendant an opportunity to provide the details of the crime. This tactic is permissible. So in summarizing this brief presentation, there are 5 points to consider. Number 1, the majority of criminals either make excuses for or attempt to justify their actions as a way to mitigate the guilt, such as the denial of responsibility, denial of injury, denial of the victim, condemnation of the condemners, and appealing to higher loyalties. These are neutralization techniques and or rationalizations. Number 2, investigators as a regular routine suggest various excuses, justifications, or rationalizations to the suspect for committing the crime, such as an accomplice talked them into doing it, the victim was accidentally shot, the subject's financial pressures caused them to act out of character, the victim provoked the situation, etc. Number 3, social psychologists and other law enforcement critics suggest that during the interrogation, if the investigator offers the subject some kind of moral or psychological excuse for committing the crime, the investigator is essentially suggesting that if the subject committed the crime for a quote-unquote good reason, they will face less punishment. Point number 4, therefore, offering a moral or psychological excuse, quote-unquote, minimizing the subject's behavior, is tantamount to making a promise of leniency. Point number 5, the courts consistently reject that premise. For more information on the interrogation process, I would encourage you to go visit our website, reid.com, and look at the investigator tips, where we have dozens and dozens of tips on what are proper versus improper interview and interrogation procedures. And of course, our book, Criminal Interrogation and Confessions. Thank you very much for taking a few minutes to listen to this presentation.